Welcome to all the participants joining this webinar. Today we are going to discuss about deal making in India, what to expect in 2023. But before we get into the topic, I just want to introduce our panelist. So I am Nishchal Joshipura. I co-head the private equity and M&A practice at NDA. To my left is Harshita. She co-heads the M&A practice. To my extreme left is Afan, who is a senior member of our tax team. And to my right is Parina. She is a member of our corporate team. Now, together with the human beings as panelists, we also invited an AI panelist called ChatGPT. And we did one interesting experiment to ask ChatGPT this question on what to expect on deal making side in 2023. So we'll give you what ChatGPT told us. But before that, just for some of you who may not be aware about what ChatGPT is basically an AI chatbot which kind of converses like a human in great detail, and it has kind of taken the world by storm in the last few months. Interestingly, if you see the way ChatGPT has progressed in the last few months, uh, Facebook took about 10 months to get its first 1 million users. Instagram took about 2 months to get its first 1 million users. ChatGPT got its first 1 million user in 5 days time. So this shows the impact that ChatGPT is going to have. Some people are already saying that ChatGPT could be the killer of Google search. People will stop searching on Google and ChatGPT is going to take over. Now, let me just tell you what ChatGPT feels about deal making in India in 2023, and this is verbatim what ChatGPT said. It is difficult to predict with certainty what the deal making landscape in India will look like in 2023. However, some factors that could potentially impact deal making in India in the next year include economic conditions. India's economy has been impacted by COVID-19 and recovery could be slow. This could impact the willingness of companies to make deals. Government regulations. Changes in government regulations and policies could impact the ease of doing business in India, which in turn could affect the deal activity. Interest rates. If interest rates rise, it could make it more expensive for companies to borrow money for deals, which could decrease the deal activity. Sectoral growth. Sectors that are growing could see more deal activity than those that are not. It's also worth noting that India is a fast growing market with a large number of consumers and companies, and it has been a major target for foreign investment. This could potentially lead to an increase in cross border deals. Additionally, the Indian government's Make in India initiative, which aims to encourage companies to manufacture products in India, could also lead to more deals in the manufacturing and production sectors. So clearly, if not the best answer, this is kind of a very good answer, especially from an AI panelist, I would say. And this is kind of changing the landscape of AI, especially large tech companies are already getting worried about the growth of chat gpt. So now moving from artificial intelligence to human intelligence, we will now ask questions to the panelists, and I'll start with the top three trends that I see for 2023 on the deal making side. The first mega trend that we are seeing, and we are already working on quite a few mandates on that, is the internalization. Internalization is basically the opposite of externalization. Some of you would be aware that in the last decade, India saw number of externalizations where large tech companies were externalized from India to Singapore and Netherlands and some of the other jurisdictions. And the idea behind that was that listing on foreign markets is going to be much easier if you have a foreign holding company instead of an Indian holding company. Now, some of these tech companies are finding it more convenient to list on Indian exchanges. So, what we are seeing is the same externalized structures that were devised a decade back, they all want to internalize and come back to India, where they want to convert the Singapore or Dutch holding companies to Indian holding companies. And the biggest challenge that we are facing, and some of the unicorns we are right now working with, the biggest challenge we are facing is most of these unicorns have their holding companies in Singapore, and how do you unwind the Singapore structure and bring it back to India, where currently Singapore company is the holding company, all the shareholders are in Singapore company, and Indian company is the 100% sub of the Singapore company. Now the simplest way to do this would be to just merge Singapore company with the Indian company and get all the shareholders at India level. Having said that, the challenge is that under Singapore local laws, there are certain issues with respect to merger of Singapore companies with non-Singapore companies, and that's a big challenge that a lot of these unicorns are facing for internalization structures. We are kind of devising structures. The most important structure here would be to just swap the shares, where Singapore company can transfer the shares of Indian company to the shareholders of Singapore company, against which the Singapore company can cancel the shares of the shareholders at Singapore company level. Again, the challenge there is some of these unicorns had made investments post 2017 in the Indian company. So any swap of shares where Singapore company is transferring shares of Indian company could be taxable event in India for the Singapore company. Similarly, if the indirect transfer tax exemption is not available to the shareholder of Singapore company, there could be a possible indirect transfer tax also for those shareholders in the Singapore company. So there are certain structures that work, which we have been advising our clients on. But the major trend, as I mentioned, for 2023 that we are seeing is internalization, where once the internalization happens, then the Indian company will list on the Indian bourses, and the shareholders kind of can get exit and can get liquid stock in the Indian company. So that's the first major trend. The second major trend we are seeing is that we are going to see is the elections, right? And from an election perspective, we are going to have elections in two major countries in the world, the US and in November 2023, and India in April-May 2024. Now typically what we have seen is 6 months before the election, the deal activity slows down, because the acquirers and the investors want certainty on which government is going to come to power, and what policies are going to be there. Can the deal get stuck in between because of the change in the government? So this is a very unique time where US election and Indian election are spread across a period of 6 months, and especially on the US side, there is kind of uncertainty on who will come, Democrats versus Republicans. And US being a major investor in India, the deal activity is going to definitely take a hit in the second half of this year, especially from US investors. And generally we see some slowdown in the deal activity in the last quarter of 2022 and first quarter of 2023 because of the Indian elections. Now as far as Indian elections are concerned, and again the views are personal, but the way currently things are going on, it looks like because we don't have a strong opposition yet, the chances of the current government coming back to power are very high. And if the current government comes back to power, then clearly it from a stability standpoint, it's good for the country. But this is something that we are seeing. There is a strong leadership in the current government, and unless there is a leader from the opposition who is as strong as the current prime minister, it's always going to be a challenge to get the current government out of power. So I think that's the second major trend on the political landscape on how things are going to shape up. The third major trend that we are going to see is acquisitive Adani. We have seen the power of Gautam Adani in 2022. He is kind of, I would say, the biggest find of 2022 for India Inc. Single-handedly, he added about $33.8 billion to his net worth in 2022, which is kind of more than the GDP of 85 countries in the world, which is more than the market capitalization of Pakistan stock market. So single person has elevated himself to such great heights that he is actually going to shape the M&A landscape of India in 2023. We already saw in 2022 the way he has set his eyes on expansion with the major acquisition of cement company Holcim, through which he acquired Ambuja and ACC. and the entry into media sector by acquisition of NDTV. So with two big deals, he has already kind of ventured into new businesses. It is expected that in 2023 he will continue to expand and set up new businesses and grow into new businesses through M&As. Is already looking at bidding for steel plant. There are talks about Adani Group venturing into B2C businesses. So clearly, they want to expand beyond the traditional infra tag that Adani Group has always carried with itself. And we are going to see a substantial boost to the IPO activity by with the five major Adani Group companies planning to go public in the next 3 to 5 years time to deleverage themselves. As we all know, they are highly leveraged. So there is going to be a substantial sale of promoter stake for deleveraging in the next 3 to 5 years. And the recent one, as we all know, they've already launched a follow-on public offer of 20,000 crore or equal to almost $2.5 billion for Adani Enterprises Limited, which is going to be launched and closed next week. So I think clearly Adanis are going to play a major role in the M&A activity in 2023, and we expect a substantial impact of 1% on the entire M&A deal landscape in India in 2023. So with that, let me get Harshita to get her thoughts on what are the three major trends that you see in 2023 that will impact deal making.
Thank you, Nishchal. And I think, as Nishchal pointed out about the general elections and how we've seen the deal activity by the Adani Group increasing in 2022, the way I see 2023, I would say three key things that come to my mind which will shape the M&A deal activity. Two largely regulatory driven and one more market practice driven. The first one being the OI framework, which was introduced later last year, which is a combination of the OI rules, the OI directions, and the OI regulations, in an attempt to liberalize and simplify the overseas direct investment rules by Indian residents. The government bought or introduced the OI framework. Now, considering the evolving business needs and the more integrated global markets, obviously this framework allowed for several relaxations. Two key ones which are relevant from an M&A deal standpoint, and which may play an important role for all deals that go in the year 2023. One is around the whole round tripping issue. So under the erstwhile regime, if you recall, the term round tripping was not defined, although the essence of round tripping was captured in the form of an FAQ, which basically said that neither is an Indian party allowed to invest in an entity overseas which has a drop down India subsidiary, nor will the Indian entity be allowed to set up an India subsidiary through its wholly owned subsidiary or a JV entity abroad. While this was always captured in the form of an FAQ, the prohibition on round tripping and the whole uncertainty around whether the RBI would bless such kind of round tripping structures has now been to an extent cleared up, with the OI rules now permitting round tripping to the extent, or I would say provided the structure has only two layers of subsidiaries involved. So basically, if an Indian entity, as an Indian entity today, it can set up two layers of subsidiaries before it can come back and set up an Indian entity in the downstream. That would allow, I think, open up significant opportunities for structuring Indian businesses where they can expand globally and then also get, easily get the revenues downstream back into India without requiring any approval anymore, and this can be done under the automatic route. So that comes as a big welcome change, and that's something we will see in most structures. As Nishal pointed out, both internalization and externalizations, where we'll see this provision or this relaxation coming very handy. Another significant change which the OI framework introduced was the ability of the non-financial services companies or entities in India to be able to invest in entities which are engaged in financial services abroad. In the erstwhile regime, just to draw a comparison, if a non-financial services was looking to invest, it actually required the a registration with the regulatory authorities in India, which has now been done away with. And so it increases the ability of the non-financial services company in India to take exposure in financial services company outside India, merely with the net profit eligibility criteria, which is posting net profits for the preceding 3 financial years. If that is the criteria it's satisfied, it should be able to comfortably, under the automatic route, invest in entities which are engaged in financial services. Now, where this relaxation would come, would be useful is structures where Indian conglomerates and larger Indian conglomerates can actually now go ahead and set up family offices, for example, abroad, which family offices can be structured as a financial services entity, subject to the laws of the local jurisdiction in which they are set up. And this will only give more flexibility to such family offices or such structures, to properly manage wealth, etc., which in a structure which was otherwise heavily regulated under the erstwhile regime. And with these two key relaxations, which would impact the M&A deal activity in 23, I think in essence what is getting handled is less regulatory intervention. So from a structuring and a documentation perspective, this reduces, one, the delay in timelines, and two, the pressure on the parties to build in monetary contingencies for such events happening. So I think that's something which will be very important and critical, when we are looking at structuring M&A deals within cross-border M&A deals particularly. I think the second, regulatory interface is the whole Press Note 3 issue. Now, as we notice, while some jurisdictions across the globe, like US and EU, always had a regime where they reviewed foreign direct investments as part of their process. For example, US had the CFIUS, which is the Committee for Foreign Investment in the US, and EU had a screening process whereby they looked at foreign direct investment proposals very carefully, specifically from a national interest perspective. Due to the economic downside or the economic impact caused by COVID-19, a lot of countries have actually ramped up or made significant changes to their existing regulatory framework with respect to reviewing FDI applications. And some of the examples could be, some of the examples of these jurisdictions are UK, Australia, and New Zealand. Obviously, the regulatory scrutiny of foreign direct investment has only increased in the recent years, not just in India, but also, I think, across the globe, in terms of how the governments would want to process such applications. And interestingly, governments around the world are expanding the scope of their review, which is now not just limited to focusing on what impacts national interest, but I think it goes beyond to deal with or analyze applications or deals even when they're not hitting the mandatory notification requirements. And I think that is where this expanded regulatory review or scrutiny is leading to extension of deal timelines. Even in a case where there are no substantive issues in a deal really, which could take so much time to close. Coming back to the Indian context and what PN3 holds for us in the year 2023, to give a quick background on what Press Note 3 is. Press Note 3 was introduced in April 2020 by the Indian government in the backdrop of, one, the COVID pandemic, and two, the whole geopolitical tension between India and China. What PN3 envisaged and the legislative intent behind PN3 was to curb opportunistic takeovers by companies or entities coming in from countries which share a land border with India. The text of the PN3 essentially mentioned that any where an investing entity is situated in a country which shares a land border, or where the beneficial owners of such investing entity are situated or are resident of a country which shares a land border, all such investments by that entity will require the prior approval of the government before the investment is made. Uh, this was obviously followed by a slew of regulatory amendments by different regulators and statutory authorities in India to bring in and align with the spirit of PN3. For example, the Ministry of Corporate Affairs also introduced an amendment to say that if a national of a country which shares a land border with India, intends to take up directorship position in an Indian company, such individual will also require a clearance, from a security clearance prior to taking up that directorship position. Now, unfortunately, what came with the PN3 was that, perhaps a hastily drafted legislation in the wake of the whole geopolitical crisis. PN3 did not define what beneficial ownership is. There is no clarity, even even with the point being discussed in Lok Sabha multiple number of times. There is still no clarity on the subject. The market practice, however, we have seen has been to rely on the 10% threshold when it comes to when it comes to declaration of beneficial ownership. And so the even without having anything in black and white from the regulators, as recent as a few couple of months back, we also notice, and we take note that from our discussion with a couple of AD banks, that RBI and the regulators are also now coming and picking up on PN3 on investments made where the beneficial ownership was as low as 5% or 6%. In the wake of all of this ambiguity around what constitutes beneficial ownership, PN3 clearly, and with the way the amendments are being brought forth in several other legislations, appears to be here for a long haul. So clearly, it will be a crucial deciding factor for all M&A deals in the year 2023. All the new entrants into the Indian market will have to very closely determine and see for themselves, in terms of what their holding structures are, who are the beneficial owners up to the last level or up to the first level of in their structures. How are they planning the manner and transfer of ownership and control? How are they envisaging that as part of the transaction where they are entering into India? All of these have to be very closely determined right at the point when you are structuring the M&A deal, or or an acquisition deal looking at India. Uh, I think another interesting point also is that there is no public data which is available with respect to how many applications are being processed, approved, and rejected by the government. The last press release, which was released by the government, was in March 2022, where it said that out of 347 proposals which the government received till March 22, only 66 were approved and over 193 were rejected or withdrawn. So with this kind of a data, I think it becomes very crucial that all foreign entrants pay close attention to how PN3 applies to them and structure their deals either in a manner which aligns with the spirit of PN3. Anything that any of the panelists may want to add to this? Otherwise, I'll move to my last point on. To the last point I see, which will again be important in terms of how the M&A deal activity will flow in this year. The WNI insurance market. So warranty and indemnity insurance as a product is a policy that covers the insured for an unknown and unforeseeable risk that arises or emerges from a breach of the representation and warranty that cannot be identified or easily quantified at the time of the due diligence. So, once really considered to be a specialty, a specialty product for which there was less demand, WNI is now a very commonplace product in the global M&A market, and India is no different when it comes to this this one feature. Most particularly in the last 2 years, with premiums ranging from 0.9% to about 2%, it's becoming a very lucrative product for all M&A deals, not just the large ones, but also for the mid-size and some of the relatively smaller deals. And the exponential increase in the uptake of the WNI, in terms of in terms of the uptake of WNI policies in M&A transaction, I think that only cements its viability in terms of being a great deal enabler, so to say. As we saw in the year 2022, a large number of M&A deals were being driven by a combination of a private equity or a venture capital investor exiting on one hand, and a strategic player, domestic or an overseas, entering on the other. In most of these cases, specifically where funds with a limited life are exiting, they wanted a limited recourse or a no recourse deal, to say that the buyer should have either no recourse to the seller post the transaction or have much limited recourse. And in such situations and cases, and in all such deals, specifically in exits, WNI insurance becomes an excellent substitute for seller indemnities, I would say. So that I think is picking up a lot, and I think in terms of the sheer numbers and the volumes in which were reported for the year 2022, in terms of deals which were underwritten by a policy, I think this should continue to be a trend also in 2023, uh, and that's how we see it. So that's all from my end.
Thanks, Harshita. I think the next major trend is, which is going to change the deal landscape from a cross-border tax perspective is the introduction of Pillar 2 Globe Rules by OECD, which is kind of going to change the way exits are going to happen in India in the next few years. So I would request my colleague Afan to talk about the Pillar 2 tax rules and how they are going to impact Indian structures, and also talk about how the competition landscape is going to shape up in 2023, and any other point that you feel is relevant.
Thank you, NJ, and thanks for setting the context really well. I am going to be talking essentially about three trends. One is Pillar 2 and the tax landscape pertaining to that. The second thing would be, like Nishchal mentioned, on antitrust implications and how deal makers have to look at antitrust implications. And lastly, I'll just touch upon a little bit on ESG. Uh, so, firstly, picking up on the tax implications and Pillar 2, right? Now, we know that since the last few years, and tax landscape is ever evolving, but Pillar 2 has been one of the most big ticket items which is grabbing the attention of the entire world. And it is, of course, likely to change the entire landscape of deal making and M&A across the world, and consequently also in India, right? So, and which is why now when people are sitting and strategizing deals, or when they're doing transactions, they will have to consider Pillar 2. So, what is Pillar 2, right? Pillar 2 essentially talks about a global corporate minimum tax. So, when the important point is that now when people are getting into deal making, they will have to consider that when they are doing transactions, that there will always be a global corporate minimum tax which ranges from 9 to 15%, and I'll come to that. And the other point that they will have to always bear in mind is that how certain exemptions under tax treaties that they were relying upon for a few structures and investments are also likely to go away. Now, with that context and the importance of Pillar 2, let me try and explain essentially how Pillar 2 works, and one or two examples how it might work. So it essentially works in two contexts. One is from a residence principle of taxation. From a residence principle of taxation, how it simply works is that if there is an ultimate parent entity that has a foreign subsidiary, and if that foreign subsidiary is taxed at a rate lower than what will be this global minimum corporate tax rate, which will be between 9 to 15%, then the ultimate parent entity, the jurisdiction of that ultimate parent entity, will have the right to top up that tax to bring it to a minimum of 15%, right? So the idea is that overall these MNCs are paying a minimum tax of 15%. Now, this has come in the backdrop of the global recession in 2008, and the OECD starting to take certain measures to try and plug loopholes that people were exploiting for aggressive tax planning, right? Because the problem that was happening is that jurisdictions were not being able to tax money in the countries where value was actually being created. So this has come in the backdrop of that, and MNCs will now have to be wary that there will be somewhere a global corporate minimum tax that they will have to think of. Now, the other context in which this applies is the source principle. In case of source principle, what the rules talk about is that if, let's say, a particular entity in the source country needs to make certain payments, let's say in the form of interest or royalties, and if the jurisdiction of the recipient country applies a tax lesser than the minimum tax, which is about 9 to 15%, then the country or the source country from where the payments are being made will again get a right to top up that tax, to apply or to levy a certain additional tax to again bring it to that minimum rate of tax. So that is broadly how the rules work. And I just want to take a few minutes to talk about how this might impact a few things in the M&A landscape. So Firstly, one of the things that people will have to think of is that when they are acquiring a particular, let's say, entity, they're going to have to think about whether that acquisition result in the threshold of pillar 2 applying getting triggered, right? So the threshold right now, the monetary threshold for pillar 2 to apply is that the revenue of that MNC should be 750 million euros. So now when people are strategizing deals, they will have to think about whether by that acquisition that threshold gets triggered, right? The other important point that becomes relevant is that a lot of these MNCs have structured their businesses in a way where they have set up some of their holding entities in favorable tax jurisdictions because of the treaty exemptions and so on and so forth. But if the top up tax rule comes into effect, then it may so happen that the attractiveness of these favorable tax jurisdictions might go away, and these global MNCs might have to again sit down and rethink about their structures to sort of try and synchronize and streamline their entities to sort of make them in line with how these rules are going to apply. The other Some of the other aspects is how the contractual negotiations are going to work out. Now when people are going to sit across deal tables talking about transactions, they will have to bear in mind what are the potential implications that may come out of pillar 2 applying tomorrow. So for example, if let's say the two parties to a deal reach a conclusion that acquiring this particular group is not going to trigger the threshold, and if let's say that position is ambiguous, then they will have to build in certain indemnities or provisions in the agreement to say that okay, tomorrow if it does get triggered, then how will the indemnity work, who will conduct those disputes, who will bear the cost of those disputes, also who will bear the cost of the pillar 2 tax if it starts applying, and so on and so forth. So that was largely on pillar 2, and I'll be happy to take
Just to add to what Afan said, in fact, this is becoming very important, especially for cross-border deals, especially for large private equity, sovereign wealth funds, and pension funds who have made investments into India in a form of a club structure where there is a foreign entity where 2 or 3 large investors come in and then they invest in the Indian entity. We are actually working on a few mandates for Pillar 2 taxation and restructuring for some of our clients. One of the interesting issues that has come up in one deal where there is a Singapore company which has kind of 3 investors. One investor is owning about 60%, other 2 investors are owning 20% each in the Singapore company. Now, this Singapore company is eligible to get a 13x exemption under Singapore tax laws, which means there won't be any tax in Singapore on the structure. They have invested in non-convertible debentures of Indian company, and that Singapore company is kind of registered as an FPI. So the withholding tax rate is only 5% when the interest is paid, to the Singapore entity, because it's less than the 12-13%. Which is the rate applicable for getting the benefit of 5% withholding tax. So overall, on the entire transaction from India to Singapore, the tax rate is only 5%. Now, as per the Pillar 2 tax rules, the minimum tax rate has to be 15%, which means there is an additional tax rate of 10% that's going to come up as and when Pillar 2 tax rules are implemented. Now, this Pillar 2 tax rules were supposed to be effective from 1st of January 2023, but they have got delayed because of a lot of representation that have gone to OECD. But it's just a matter of time. It could get implemented anytime, mostly not later than 1st of Jan 2024. And which is why a lot of these large funds, especially sovereigns, pensions, and large PE funds that have invested in India through club structures, they are all kind of they have started doing restructuring of their holdings in that foreign entity, because one of the exemption that is available is if one of the major shareholder owns more than 95% of that foreign entity, then you get the benefit of the some exemption which is there under the Pillar 2 rules, and then you don't have to pay that additional 10% tax if you are already paying the 5%. So a lot of restructuring happening, and as Afan mentioned, it's also going to be interesting to see once Pillar 2 kicks in, whether this could impact the tax treaties that India and Mauritius and India and Singapore had entered into earlier, where the grandfathering of investments of pre 2017, would that grandfathering be applicable to the cap gains tax benefits which were available to investments uh, that would be applicable. So the rules are very complex. The pillar rules are quite complex, and it needs to be seen whether uh, you know some of these treaties would be challenged later on because of the pillar 2 rules being applicable. And that's also something that we are kind of working on some of the assignments for some of the clients. But sorry, you can.
Yeah. Thanks for supplementing that, Nishchal. The other thing that I want to talk about is the antitrust implications in M&As. Now we have seen in the recent past that this has become a sticking issue because and deal makers are having to sit back and also think about the antitrust implications of certain M&As. Specifically with respect to whether there is a requirement to notify the CCI and whether there is a requirement to get an approval from the CCI. Last year, the Competition Commission amendment bill was also introduced, where the idea was to introduce a certain threshold for deal value, which was INR 2000 crores, and if the deal value would, uh, you know, cross that threshold, then the law states that an approval, specific approval, would be required from the Competition Commission. Now, while that does try to bring about some certainty in terms of when that approval needs to be acquire to be sought, but it also sort of brings in an additional sort of compliance or checklist item that needs to be carefully looked at when people are crafting their deals. And I think the that is in terms of what the law is and what the law is likely to be. But another thing is also the way the law is implemented and the approach of the enforcement agencies. It is important that these enforcement agencies work in a way that is pro business and pro deal making, because only then are we going to see like the actual result of it, which is through deals, economic growth and economic development. And these enforcement agencies shouldn't really be like a block to that. A simple example is when we saw that what happened with the Amazon future deal, where the Competition Commission had earlier given the approval for the deal, and at a later point in time they came and they had withdrawn that approval. Now with the enforcement agencies taking steps like this, builds in like somewhat tries to bring in some sort of uncertainty in the minds of businesses and entities in India, and also sort of creates more doubt as to the landscape of a pro business or a pro M&A kind of a landscape or an environment in India. So it is only hoped that these enforcement agencies take cognizant of this fact, and they make the process more streamlined and more easier, so that antitrust implications can be dealt with in a more seamless manner, so to speak. So
Yeah,
if you want to add
just to,
something.
yeah, I just want to add one point. I think the antitrust regulations have become very important for deals in India, especially because of some of the interpretations with which Competition Commission of India has taken in certain matters, including the fact that even one observer seat is considered as control from a CCI perspective, which is very different from the way control is looked at by other regulators, including SEBI and RBI and IRDA. So clearly, the thresholds are very low when it comes to interpretation of notification requirements for Competition Commission. So before making any investments or any acquisition, it is very important to analyze the deal thoroughly, including the fact that there is also a concept of interconnected transaction under competition law, which means that even if you are doing some simultaneous transaction in the company, which could be considered as interconnected, then before you do that transaction, if the other transaction is notifiable, you cannot do the first transaction also, even though independently that first transaction was exempt. So this is also something where CCI has been upping its scrutiny on the deals, and I think 2023 will see a major change in the way CCI is going to be looking at deals. Interestingly, right now There is no quorum in CCI. You need 3 members to approve the deal. So there are only 2 members right now. The third member has not yet been appointed since quite some time, because of which deals worth more than 10,000 crores have been stuck with CCI. So that's also something which kind of is not good for the deal activity, and we hope that the third member is appointed fast so that some of these deals can start getting cleared.
And and just to add to that, I think it's not only important when you're looking at an acquisition deal directly into India, but also at an indirect level. So when you are, let's say, changing hands or control is changing at an indirect level with respect to an asset situated in India, that's also when a CCI analysis is required to be undertaken. So we need to be just mindful of that even when we are undertaking structures or undertaking any kind of structuring completely alienated from India, but the underlying asset is situated in India.
Yeah.
What do you,
So just take a couple of minutes to talk about ESG in the landscape of in the M&A landscape and the expectations. So we all know that some of the key trends that we've seen in the past are things like, let's say, climate change, things like financial fraud at the level of board of companies, and aspects of corporate governance. So in this backdrop of course, ESG has become a very important consideration. The three-step matrix of environment, social, and corporate government factors has become very important. Now, I mean, it is of course known that ESG has not really come into the mainstream yet, but I think the positive bit is that there has still been some improvement. Now, what is happening is that SEBI has come up with certain reporting requirements for the top 1,000 listed companies, and even otherwise there has been generally some awareness. Most importantly, and I know Parina is going to touch upon this, because of shareholder activism, the boards of the companies are also now feeling compelled to ensure that companies are wanting to meet the ESG standards at least. So with the rise in traction on ESG, some of the things that we should or we could expect in the M&A landscape is that things like pre-transaction discussions and even due diligence items are going to include things like how do companies deal with, let's say, anti-money laundering laws, privacy laws, human rights laws, diversity laws, and so on and so forth, right? And I understand that for businesses it might be challenging to sort of comply with these because it comes as an added challenge. But if it is looked at in good light, and if it is like sort of implemented in spirit, we are looking at a better future in terms of cleaner MNCs and more ethical MNCs, so to speak. Over to you, NJ.
Thanks, Fan. Moving on to Parina. Parina, would you like to share your thoughts on couple of trends for 2023?
Sure, Nishchal. So, in terms of trends, I think there are two key trends that will continue to dominate M&A in 2023. The first one, as a fund mentioned, would be rising shareholder activism. So, what we've been seeing in India over the past couple of years is that there's been increase in shareholder awareness and activism, which is leading to a large amount of change in companies whereby shareholders are questioning management decisions increasingly. For instance, if we take very few recent examples, such as in cases of management decisions related to Bajaj, Iker, Hero Motocorp, there were management decisions saying that the remuneration for CXOs should be increased. However, the shareholders came in and opposed that particular resolution, saying that given the fact that these companies don't have enough revenue during COVID and are already having a large number of operating losses, this would not necessarily be the right decision. And in that spirit, these decisions ended up being overturned. What we're also seeing increasingly is that this is a phenomenon that's not just being witnessed in India but also abroad. A very popular example is the case of the board of Exxon. Engine number one was a minority shareholder which garnered the support of the other shareholders and forced the Exxon management to consider passing a resolution to reduce carbon footprint. So what we're seeing is that there's activism not only to increase shareholder value but also to increase compliances in relation to ESG, the ones that Afan pointed out earlier. The other important trend that we're really looking at when we look at shareholder activism is the increasing importance of proxy firms. Proxy firms have of lately been advising large institutional as well as smaller retail shareholders on key decisions relating to managements. So, for instance, if we look at the decisions in Carlyle and Punjab National Bank was initially allotting preference shares, as a result of which it was losing a large amount of control, and Carlyle, an institutional investor, was gaining a large amount of control in the company. SES, being a prominent Indian proxy firm, went to SEBI and opposed this particular board decision, saying that not only is the pricing of the preferential shares unfair, but the fact that it's only being allotted to certain select shareholders shows that this is bypassing the intent of the minority shareholders and protections awarded to them under the law. Finally, although this issue was heavily litigated, what eventually ended up happening is that the Supreme Court of India ruled in favor of SES. This only goes to show the increasing impact that proxy firms have in increasing corporate governance ethics in India. And we don't just see it in this case, we also see proxy firms providing similar advice in relation to management remuneration, in relation to reappointment of directors and managing directors on the board. Notable examples are in relation to the board of Paytm, where SES, IIAS, and InGovern, three prominent Indian proxy firms, have collectively issued a statement saying that this reappointment goes contrary to the spirit of company law and leads to continued appointment of the managing director, which contravenes the intent of the law. So this is in terms of growing shareholder activism that's been there in India. And the other important trend that I've been seeing of lately is there's been an increasing resort to buying stressed assets through M&A. In India, the course that is usually resorted to in relation to stressed assets is the Insolvency and Bankruptcy Code in 2016. Now, ever since COVID pandemic, the Insolvency and Bankruptcy Code had been momentarily paused, and its applicability was paused in the interest of growth of businesses. However, ever since its applicability has been re-extended across businesses, what we project to be an important trend is that M&A will be increasingly resorting to the IBC route to purchase stressed assets. If we look at the pre-COVID era, we just see a lot of examples that further elucidate on this point. Common examples would be the acquisition of Bhushan Steel by Tata, or the acquisition of, say, Arcelor Steel, and also the recent and extremely popular example of the acquisition of DHFL by the Piramal Group. So what we increasingly anticipate is a resort to IBC, but what is important and should be considered when going through this route for potential acquirers is the fact that this is a statutory process which would require potential acquirers to abide by statutory timelines as well as statutory requirements in relation to resolution plans, etc. So while acquirers might consider these routes as very profitable in the long run, it's important to consider the fact that these processes lead to a large number of related regulatory compliances that might also have to be evaluated in light of deal timelines. So these are just the two key trends that I think would continue to dominate M&A in 2023.
Thanks, Parina. I think on the stressed asset side, given the looming threat of recession in the US, Europe, and China, we expect that the second half of 2022, there will be a lot of businesses in distress in India, and we will see the deal activity pick up from the stressed asset acquirers and the stressed asset funds. We'll see a lot more ARC deals happening, lot more deals on the good asset side through securitization structures happening. So I think there is a lot of opportunity that we see in the second half of 2022, including the fact that in addition to the stressed asset, even in the venture capital space also, we have been seeing quite a bit of dip in terms of the valuations of the startups or what you call unicorns, where clearly the model is now being shifting from revenues to profits, and we are expecting a lot more down rounds in number of startups and unicorns in the second half of 2022. So I think broadly, these are the trends that we expect to see on the deal making side in 2023, and we'll be happy to take any questions that the audience has. So I think there is one question that has come up on whether the Pillar 2 will override any concessional rate provided under tax laws of any specific jurisdiction. The answer is yes. We are working on a mandate along with some of the foreign tax law firms, and this is a situation where the Singapore entity, as I mentioned, is exempt under 13x regime in Singapore, and in spite of the fact it is exempt, given the fact that the income that it receives from India is only subject to 5% withholding tax rate, there is a gap of 10%, which is the minimum 15% tax rate that is required to be paid as per the Pillar 2 tax rules. So that gap of 10% has to be paid by the Singapore entity unless some restructuring is done in that Singapore entity where it falls within the exemption. So to answer your question, yes, it is going to override the tax laws of a particular country also. And that's why it is kind of a major game changer, for cross-border deals, where in addition to the local taxation, in addition to the host country taxation, and in addition to the tax treaties, even the pillar 2 taxation has to be examined going forward for any deals in India.
Yeah, just to supplement that in one line, it's almost like a good analogy would be minimum alternate tax in India, right? So where one of the important things that matters is that a lot of companies, after all of their concessions and everything, if they end up paying below a certain rate of tax, then MAT ensures that a minimum amount is being paid, which is that's the philosophy behind Pillar 2 as well. And to that extent, it is likely to override concessions, specific concessions in jurisdiction.
So we'll take up the next question on from Sandeep on, given the large scale layoffs happening in the international IT industry, what do you think could be the impact in India vis-a-vis employment and industry laws, right? So one is the labor code has been has been waiting for an approval and seeing the light of the day for a long time. We are still not sure if the labor code will be implemented and enacted in entirety this year. So that and the labor code may put at rest a lot of a lot of uncertainties and the archaic labor laws that the country has seen over a period of time. So that would be a welcome change, although it is not certain on when it would be implemented. In terms of M&A and employment, I think the methodology adopted usually in M&A transaction with respect to either laying off employees or transferring the employees, that may not change. That will continue to be as is, which is either like in an acqui-hire transaction or otherwise, where we take over the employees by way of resignation, rehire, or an automatic transfer of employment. I think that that approach will not change and will continue to be be prevalent in the M&As going forward, whether direct or indirect acquisitions, where two, as we've seen as a trend picking up last year, a lot of these US to US acquisitions, or a lot of indirect acquisitions which had an India subsidiary, which was a service base for most transactions. Employees were transferred as part of the transaction to the new entity. So that, I think, would continue to remain as is, and we don't see any change there.
Great. Do we have any other questions? Okay.
Sorry, there is one question.
No.
Thanks. The tax rate is 17. Sorry, there is one question before
So
that.
yeah, there is a question from Harsh Saraf. In Singapore, the tax rate is 17%, which is above global minimum tax rate. The point is that a specific exemption is provided specifically to the fund. So with analogy, tax concession exemption provided by a specific jurisdiction may not be of any help in case of a cross-border transaction. So so I think, Harsh, the point is, as we mentioned, first of all, this Pillar 2 tax rules are very complicated, the way they are drafted. Second is, even though the local tax rate may be 17%, but what is the actual tax you are paying is what matters, not the overall tax rate applicable to corporates that are not exempt, right? So it's the same classic debate of liable to tax versus subject to tax, which we have in the tax jurisprudence. So the point is that if you end up not paying any tax in Singapore, and which is what, as we mentioned, we are doing a live restructuring where this issue has come up, and all Singapore tax lawyers, US tax lawyers, everybody is involved in that. And the view that is there is that after reading the OECD Pillar 2 rules, if you are not paying any tax, you need to cough up that amount, which is the difference between 15% tax rate and the rate which is actually the tax that has already been charged. So to that extent, you will still need to pay that additional tax unless you do some restructuring. And there are few exemptions that are available. Those exemptions are if you do proper restructuring, you may be able to fall within the exemption. But again, it all depends on the facts and circumstances of each case.
Sorry, can you just go up, Mukesh? What happens in case a country refuses to adopt Pillar 2?
I can take this.
Sure.
So okay, so I'll take the question from Jagravi. What happens in case a country refuses to adopt Pillar 2? Just for the sake of discussion, in your example, what happens if Singapore, where the parent entity is a resident, does not agree to adopt Pillar 2? Who gets to levy the top-up tax? So the answer to this is provided in the Pillar 2 rules itself. What it provides for is a backstop rule, or the undertax payment rule, called the UTPR. Now, what that simply means is that, let's say that the jurisdiction in which the ultimate parent entity is located does not adopt Pillar 2, then of course that jurisdiction will not get to top that tax up. In that case, you will have to look at other jurisdictions where some other group company might be located. And if that jurisdiction has adopted Pillar 2, then Pillar 2 will be implemented in a way where that group company will be able to top that tax up. And how will it do that? It will do that by way of denying deductions, tax deductions, to payments that the company in that jurisdiction needs to make to the subsidiary on which the rate of tax is less than 15%. So in short, if it does not apply at the level of the ultimate parent entity level, it will apply at the level of some other group company, provided it is in a jurisdiction that does adopt Pillar 2. And that's how the UTPR rule works.
You want to take up the next one on global minimum taxes? Can you share an opinion on the impact of NRI and foreign nationals?
You will take this one?
I'm just going to read 1 minute. Can you share an opinion on the impact of NRI and foreign nationals in the digital system that is acquired as stressed asset? Impact of NRI acquiring a stressed asset.
So I think the next question is from Dhara Thakkar. Can you share an opinion on the impact of NRI and foreign nationals, individual investors into India entity that is acquired as stressed asset via M&A transaction and its tax implication? I think the question is very broad because there are a lot of variables that are required to determine the tax implication. For example, how is the investment going to be made in the Indian entity? Is it through a securitization trust structure? Is it through an ARC? Is it directly through a non-convertible debenture structure, which kind of replaces or refinances the existing loans? So a lot of variables are there, or is it just sometimes the borrowing is done directly at offshore level, and at India level there is just a simple M&A transaction. Given that in India leveraged buyout transactions are not very prevalent because there is a restriction from Reserve Bank of India for lending to Indian corporates for acquisition financing. So everything will depend on the type of structure that we use. There is no one answer to your question. It will depend on, at least there are 4 to 5 structures that are used, and for each structure the answers would be different. Okay, so I think we are done with all the questions. Thanks to all of you for taking out your precious time for joining this webinar. Hope all of you are taking back something valuable from the session, and we'll be happy to hear any feedback that you have for us. If you want us to cover some more topics, in our next webinars, which you feel are you are interested in, we'll be happy to do that. So please feel free to give us the feedback. Thank you so much once again, and hope all of you have a great day. Thank you.
Yeah. And in case you have any questions which remain unanswered from this session, you can mail us, mail the panelists, and we'll be happy to take up and respond.